It is stated that several candidates who have been given blank OMR sheets have been empaneled. It is further stated that in the aforesaid selection process, merit has been compromised. But from my end, I could not get any better information because RTI information have been refused to me.
If you can bring this, I understand what you want to bring in. Now, the Honorable Supreme Court has specifically observed the decision of the cabinet to create such post cannot be the subject matter of whether investigation or decision itself. The decision cannot be exposed to any investigation before the court also. Yes, cannot be.
Right.
But in such event also, if he can take me to that place where he can satisfy the court that the supernumerary post can be created in a given situation, which is not in existence when you created it. This is for challenge, to throw challenge to the entire selection.
Yes.
Now, his initial petition, as I could gather, was that state cannot create this post. In a given situation, state can, but this is not a situation where state can. This was the, oh, you have become so smart. Everything.
No, I was always unsmart, you know that.
It's all about, nothing to add to it.
Milord, today, Milord, whatever has subsequent...
Doctor, please answer my question. Nothing to add.
This channel does not promote any violent, harmful or illegal activities. All content provided by this channel is meant for an educational purpose only.
Milord, the vacancies, Milord, which are created, new vacancies, it ought to have been, Milord, kept wide open for all. It was only confined to a particular group, saying waitlisted candidate that there is no question of waitlisting in terms of rules.
Very well.
So I am really questioning, Milord, the authority of the state to, Milord, create supernumerary posts under the garb of filling, Milord, the open post.
So you had participated in this,
yes,
but you were unsuccessful.
No,
if we go by the 2016 result itself.
In this matter, the petitioners are, Milord, not the participant in 2016 group.
Yes.
For work education. For work education, participant. Now, when you create...
participated in respect of the work education only, or work education,
yes,
physical
work education, physical education.
Work education and physical education. Or only work education? Please clarify.
Work education and physical education.
Sir, please clarify.
Work education.
Only work education.
Yes. No, work education.
Can I get a statement?
Paragraph 2 of the petition is only restricted to work education.
Paragraph 2 is categorical that the petitioners were applicant for work education at the upper primary level.
If that be so, there is no challenge so far as the physical education part is concerned.
Same matter pending. Same matter pending. Physical education matter pending.
Another petition is pending.
Yes, for physical education.
This is for me. Physical education challenge?
This is 2020. No, this is not part in part, since your lordship is only hearing.
Assigned. This is assigned matter.
No.
Assignment is react. Now the issue has become much more easier for us. CBI has submitted a charge sheet that they have categorically mentioned that this post of physical education, work education have been sold in the market. Yes, kindly see this supplementary affidavit.
So you are using a supplementary evidence.
Affidavit. Annexing the.
Is it for work education?
Yes.
And so far the physical education.
Physical education, work education, are not the same group.
Add on.
State ke dao. State document.
We are already parties.
No, already not parties.
Now, if you come to your prayer,
my lord. No, I am making a prayer for publication of OMR sheets. That's the most transparent and fundamental issue. If the OMR sheets are published, automatically the results should be apparently clear to the court. Our prayers are, my lord, multiple prayers in the petition.
Now, 2016 selection process, the entire selection process has been quashed.
No, not this process.
Wait.
The entire selection process, my lord, has been quashed for Group C, Group D, 9, 10, 11, 12 teachers.
Group C, Group D.
Group C, Group D, non-teaching staff, and teachers for class 9, 10, and 11, 12.
Please show me from the order.
My lord, kindly.
Just a minute. Show me the order. And the recruitment advertisement
Yes.
was common or separate for work
Separate.
education?
For this separate.
For this separate. Please clarify this.
Lord, kindly takes up, my lord, the order of the Honorable Supreme Court, 3rd of April.
Yes.
The petition.
No, no, wait, should to do that. My lord, kindly come to, my lord, the judgment of the Honorable Chief Justice. The impugned judgment dated 22nd of April, R block, sets aside the 2016 selection process conducted by the West Bengal Central School Service Commission for the recruitment of non-teaching staff in groups C and D and assisting teachers for 9, 10 as well as 11, 12. This is the issue. And the entire thing was set aside.
Now, then show me that this
Work education is separate.
was a
Yes,
separate
kindly-
advertisement.
Kindly come to, my lord, the advertisement. Oh, Chinese colony. Advertisement about it? I need down our advertisement.
I cannot see it in that way. Give me a copy if it
I'm
is
just-
not part of the record.
You know, this is a part of annexure of Can 8, but anyway, Lordship can look at it. And it's down, you can supplement it only. I didn't remember. হ্যাঁ
কোন জায়গায় দেখাচ্ছে সিবিআই বলেছে
বলুন প্যারাগ্রাফ
Page 9.
ওইটা কোথা গেল
Nine.
সাপ্লিমেন্ট
Page 9.
এই অ্যাডভাইসমেন্ট ওখানে আছে তাহলে কেন বকার মধ্যে কথা বলবেন
এটা একটা সেপারেট জেরক্স করে দেবেন আমাকে।
এটা ও জানতে চাই সেই উত্তরটা দেবে বাড়তি কথা বলবে না
Yes. This is therefore
This is a separate advertisement, separate recruitment process, separate way of dealing the scam, but in a similar manner.
very well. Now,
The
a
kindly
list
takes
of-
up the supplementary affidavit just now I have filed. This is very important. Now your lordship will find the similarity, if not the identity, with the 2016 selection, which was quashed. Page 19 of the supplementary affidavit.
মোশন
The paragraph 17.13 of the charge sheet says, may I read out in court? Investigation has also revealed that Arun Kumar Hajra, alias Chinu, was an agent of accused Sujoy Krishna Bhadro and had collected about 78 crores from the undeserving candidates of primary teachers, upper primary teachers, Group C, Group D assistant teacher, 9, 10, organizer primary, real, physical education and work education. Through his sub-agents and had delivered it to Sujoy Bhadro directly to Nikhil Hathi as per the direction of Sujoy Bhadro. It has been further revealed that out of rupees 78 crores, 11.50 crores was paid towards arranging of appointment as primary teachers. Therefore, the allegation of corruption, Milord, is also, Milord, very apparent and pertinent to the issues pending before my Lord, apart from the constitutional issues. But I would rather appeal to your Lordship, Milord, kindly decide the matter as a constitutional and administrative law issue, and then, Milord, the corruption involved, how it was done, and to make it that, Milord, beneficial for everybody's to understanding, the Weimar must be produced before the court.
Sir, one thing. After the Supreme Court judgment, the Supreme Court has clarified. The clarification is that
Charlie, excuse me, this fan creates problem for me. I'm just wearing the hat.
you look nice by the hat.
At least not when it said so, you will not blame us. আমরা টুপি পরি
না না আমি নিজে পড়ে দিয়েছি নিজে পড়ে
By he himself has done it.
That's right.
Where is the cabinet decision?
And do not in any way impinge or reflect upon the investigation of charge sheet filed by the CBI on
Or
other
otherwise.
aspects. So, sir, after this observation that it cannot be looked into, this observation whether really any have impact on this charge sheet or the criminal investigation.
Therefore, the investigation is going on. I am not.
Can it be?
I am only, my lord, pointing out to Honorable Court that this recruitment process, which is now before your lordship, also comes within the purview of scam and corruption. So one point.
Even
Yes.
if it is done,
No, lordship need not go into the question of investigation. I am not on
yes,
that. I'm not on that. Probably but I say that to fulfill that purpose, my lord, since we had prayed that the Weimar publication is very important. Our basic allegation was manipulation in Weimar, and to give them the protection, these numeric posts are created. These are all correlated. And then the question is, can the state, even the President of India cannot, my lord, act beyond the rules and the constitutional provisions set to judgment of the Supreme Court. Therefore, this cannot be said that the cabinet decision, therefore you cannot touch us. That might be one of the argument I'm apprehending. And
cabinet decision which cannot be touched, as the Honorable Supreme Court has also held.
Supreme Court did
Therefore,
not held it. Supreme Court just quoted the provision of the Constitution and said no criminal investigation. Supreme Court did not declare that these issues cannot be gone into, because even the cabinet memo, it says subject to pending writ petitions.
Shall not be inquired into by any court is the observation.
That's observation, but I will
Kindly cease.
this observation will not cannot.
The aforesaid direction is therefore set aside.
Aforesaid direction is investigation.
cannot be inquired into by any court. What is that?
That means the
Propriety
cabinet
of the cabinet decision.
No,
Propriety.
investigate. It must relate to the investigation. The court
with
says that.
respect, with respect, no. Kindly read the last
No,
portion
yes,
of the
yes.
order where the Supreme Court is referring to the
Yes.
Constitution.
May I read out, my lord? Let us get ourselves clear. In paragraph 2 of our judgment, it was held that the issue with regard to the direction for investigation by CBI. That order of the court should be read in its entirety. In first page, in paragraph 52 of our judgment, dated so and so, it was held that the issue with regard to the direction for investigation by the CBI vis-a-vis the decision to create supernumerary post would be dealt with separately. Therefore, this creation of supernumerary post vis-a-vis CBI investigation.
That this was the issue framed by the Honorable Supreme Court to be investigated separately. Now, while dealing with it, what are the observations?
Let me place it. In particular, our attention was drawn to paragraph 257 and 265 of the impugned judgment. 257, 265 of division bench judgment category case, they must take them into custody if necessary and carry on investigation. Therefore, the Supreme Court was again confining its decision making with regard to those two paragraphs. Then case says, we have considered the observations made in the aforesaid paragraphs on a pointed question. It is accepted that in the writ petitions, no specific prayer was made challenging the cabinet decision, but this petition now challenge is there. Consequent to which order dated 19th of May 2022 was issued by the government of West Bengal after approval of the governor. No prayer was made that this order should be made the subject matter of any investigation. Look, this is not any other aspect of constitutionality. Any investigation by the police or the CBI. Perusal of the note dated so and so, which makes out a case for the cabinet decision, reflects that it was recorded under section 19 of the West Bengal School Service Commission Act may be used in respect of waitlist candidates. But the same shall be subject to the outcome of pending litigations before the High Court at Calcutta.
Section 19, please.
Yes. Now, that I have annexed, my lord, these rules are annexed. Section 19.
Section 19 is in
These are the
headmaster's first volume.
government's power to issue direction.
First volume.
Black corona কেন আমি তোমাদের পুরো প্ল্যান করি কোটেজ পাতা
490
এরকম কি দেখাচ্ছে 424
আবার পাতা মিলবে না তো
স্কুল সার্ভিস কমিশন
হ্যাঁ 490 বলছে yes kindly Miller takes up this into section 19 আমাকে দাও দিচ্ছি
জজ সাহেবের বই না আমার
Section 19 is very specific and limited to a particular arena. directions by the state government. In the discharge of its function, the commission shall be guided by such directions as may be given to it by the state government from time to time. Now, this is the empowering section. Now, my challenge is whether this section
In conformity with the
let's say,
provisions.
therefore, basic thing remains. The Supreme Court did not say that the action of supernumerous creation was valid. No. On the contrary, Supreme Court, the issue is pending before the High Court. That is itself is the inherent.
No, that part I understand. That I will be
And then
hearing
court-
on that.
and-
But that my query is
I just let me read out one thing. Then let kindly come to know that having regard to the aforesaid discussions, we are of the view that court was not justified in referring the issue of creation of supernumerary posts pursuant to the cabinet decisions for investigation by CBI. Now, this is the only thing which the court was concerned of. It may be relevant to take a note of clause 2 so and so that the question whether any and if so what advice was tendered by the council of ministers to aid and advise the president or tendered by the ministers of the cabinet to the governor shall not be inquired into any court. What is not inquired into? What advice was given? That the Supreme Court quotes from the constitutional provision, that could not be inquired into. Therefore, aforesaid direction, what direction? That the CBI should conduct an investigation is set aside. Then we, however, clarify that our observations and directions given in the present order are limited to the extent of the directions for investigation into creation of supernumerary posts and do not in any way impinge or reflect upon the investigation and the charges filed by the CBI or on other aspects. Therefore, the Supreme Court was very kind, because I was there when I was seeking this leave, that issue not when they passed.
On other instance, on other aspects, on other aspects.
Supplement the
I'm constructing the English.
filed by the CBI on other aspects.
Now,
Reflect upon the investigation and charge sheets filed by the on other aspects means
but that will be not the issue.
of other aspects related to the
No, investigation is quashed. Therefore, nothing remains of other aspect investigation.
Investigations with CBI.
Therefore, the read court's power to go into the issue
now
of constitutional.
the charge sheet you are showing. Charge sheet specifically indicates money trail on
Even on this,
this work education and physical education.
even Milord, in this matter, Milord, we did not have any idea that this matter is also part of money trail or scam. That we come to know gradually when the charges are filed. Therefore, the issue of constitutionality remains to be decided, which the Supreme Court did not touch and could not touch, because Supreme Court says we are confining only to the issue of direction by CBI, as direction by the court to CBI, nothing else.
Regarding the creation of the
Supernumerary
ministers,
post.
councils of ministers advice for creation of the supernumerary post.
Now, Milord, let us go by the law.
Now, the what is you have supplementary affidavit. You have
Supplementary, I wanted to show, begin notice of the court, that even this recruitment, which was not really before the Honorable Supreme Court, is part of the scam.
The contrary argument was being advanced all throughout. All throughout. Milord, your lordship was persuaded.
Either I finish or let him start or let him complete, I don't mind. Let us go one by one. Let us not follow the bad example of Supreme Court. The 5 lawyers will shout at a time.
No one is shouting. We are just pointing out.
Shouting means,
Milord, without meaning any disrespect to my esteemed senior, Milord, the
let us proceed.
endeavor was
invited you.
very.
Now, what is the impact of it? Now, you are if you go by your prayer.
Yes, kindly come. My prayer was
Any allegation of any money trail or
It's not there.
illegality in the
we have
pleadings?
mentioned, but Milord, we could not give any material to support.
Very well. Any pleadings to
Yes,
that?
yes. Kindly come. That is there. Well, a very short petition, Milord, may I just place the relevant portions. Paragraph 5 and 6. আমাকে ঠিকমতো পড়তে দাও, বসো। চুপ করে বসে help করবে। Your petitioner state on scrutinizing the merit list, several discrepancies, illegalities have cropped up. Several candidates who have obtained low academic scores have somehow got very high scores in the written examination. Such instances are given below. Then, next page, it is germane to mention here that these are only a
These
few
are waitlisted candidates or
Yes.
in the original merit list?
waitlisted candidate Milord in the original selection and some empanel.
Please refer to the first column.
Yes.
Of
First
the-
column is with a name, academic score, written score.
Serial number as in
Merit
merit
list.
list.
Reading code, page.
Serial number as in merit list.
Yes.
Merit list meant they were selected candidates.
Yes.
Now we are concerned about the waitlisted candidate. There are two aspects of the matter. If you cannot succeed, then the waitlisted candidate would be accommodated in the supernumerary post. But before allowing so, when the issue you are developing that the waitlisted candidates are also tainted, in your writ petition, is there any challenge to that?
Come. Let's just give me 2 minutes, Milord. It is stated that, page 9, after the table, there are several candidates who have given blank OMR sheets, have been empaneled. It is further stated in the aforesaid selection process, merit has been compromised and appointments have been given in lieu of money. It is stated that in this regard that from order dated 20th September 2020, it has been found that the Central Bureau of Investigation has filed a report regarding the School Service Commission recruitment scam, which is now a concluded decision by the Supreme Court. Then paragraph 6 below the RTI, then kindly turn to paragraph 8. Your petitioner states that many of your petitioners have also tried obtaining information by availing the Right to Information Act and have got no propitious reply, and it gives opportunity to the concerned respondent authorities to delay the process. It is stated in this regard that petitioners have already waited a long time, and without the intervention of the Honorable Court, petitioners shall be suffering irreparably. Your petitioner state that without having access to their original OMR sheets and tally it with the respective question booklet and answers, it is not possible for a petitioner to know that their OMR sheets have not been manipulated with it. Also stated in this regard that it is imperative that your petitioners get access to the original OMR sheets of the candidates who have been empaneled in the merit list and the waiting list, since there are many candidates in the empaneled list who have very low academic score but have conveniently obtained disproportionately high marks in the written examination. And therefore, given the plethora of discrepancies and the respondent authorities have already been held accountable for, your petitioners cannot be absolutely sure without scrutinizing OMR sheets. Then kindly come to paragraph 12. Then we petitioners state that to your utter shock, they found that the respondent authorities by an order dated so-and-so created 1600 supernumerary posts of assistant teachers with breakup of so-and-so, all for absorbing wait-listed candidates. But this is a very important aspect of the deliberate glaring violation of the rules and the constitutional provision. The aforesaid notification is absolutely arbitrary, unjust, and not tenable in the eye of law, inasmuch as the respondent authorities have no authority under the law to create supernumerary posts absorbing all wait-listed candidates. Be it stated that such action of the respondent authority is nothing but a big scam to cover up the corruption in the selection process, and as such the respondent authorities have no authority and the jurisdiction to create supernumerary posts. Therefore, these fundamental things are there, I am not repeating.
No, there are two aspects of the matter. You may throw a direct challenge to the authority or the capacity of the state to create such posts. The purpose to absorb the waitlisted candidate. I want to know from you to correlate with the observation or the finding of the CBI charge sheet. Is there any allegation in the writ petition that the waitlisted candidates are also tainted?
No, I have said so. Once again, I am reading the paragraph which I have read out.
Paragraph 12 is the capacity or the authority of the state.
No, paragraph 5. I started from reading from paragraph 5.
That is, they have been given appointment.
Yes, no, and with the several candidates, paragraph 5 will not continuing. It is stated that several candidates who have been given blank OMR sheets have been empaneled. It is further stated that in the aforesaid selection process, merit has been compromised. But from my end, I could not get any better information because RTI information have been refused to me.
So your challenge is the entire thing. Those who are in merit listed and wait listed, both cases, there was merit was compromised, and this is your general challenge.
And to cover up this misdeed, since people were agitating, government took a decision that we will create posts for them. Let them be given the cake, they will be silent. That was the whole game plan. And that will be apparent from the agenda of the cabinet.
So this charge sheet of the CBI is in evidence in aid of your
Yes, that's the point.
that you want to bring in.
Why not?
And
my
according
will
to
be
you,
pleased to, if Lordship show blood feels, direct the CBI counsel to produce the entire record before Lordship with regard to this aspect.
that I will do. But tell me, CBI is a party over here in this matter? Is not a party. You just tell me now. This now the next prayer of yours. Let me have a quick look before I forget.
I just read out multiple prayers. Now, that is prayer A with regard to OMR sheets. B, again to publish the OMR sheets of all candidates who have been enlisted in the merit list and the waiting list, along with their application forms in respect of the 2016 SLST. So that
merit list has already been published.
Without disclosing OMR sheets. Then we'll have prayer C, CBI investigation. I am not on this now. Then D, terminate all the illegal appointments recommended by the School Service Commission. Thereafter, recast the entire panel.
So it is not the challenge to the waitlisted candidates alone. This is entire
system, entire process.
How many vacancies were there in the selection test of physical education?
Well, they say
SSC.
What we can say.
Respond, please. Physical education, work education, class 9-10.
No, upper primary 9-10 both. Physical education.
Upper primary, work education, physical education.
This is for upper primary.
This repetition.
Upper primary.
Upper primary work.
এটা দেখুন employment notification টা একটু আগে দেখালে যেটা দেখো।
Yes, the upper primary. School Service Commission, selection of appointment for the post of teachers for upper primary level schools. State level selection test for recruitment.
Upper
Vacancy is also not, I believe, the
number of vacancies.
The total vacancy was below 1237. Work education, 1019 physical education. No, that is a part of the advertisement itself. Maybe 4th page of advertisement.
There is nothing. Page 1 you have given me only.
Page 1 দিয়েছিল
না আমরা দিইনি ওটা কমিশন
কমিশন দিয়েছে
এই পুরো অ্যাডভার্টাইজমেন্টটা আমার লাগবে আলাদা করে
that's the full advertisement there.
Not a part of that separately. To provide me separately.
I will share the handover to just teach out more and ওটাকে খুলে
which page? Number of post? Oh yeah,
4th page. Physical education and work education 1019 1034 something like that.
1237 for work education.
And physical education?
It's not the physical education.
Yes,
it's not before me.
Yes. Just the next column.
No, the writ petition challenging.
Petition is only work education.
No, can you show the physical education or work education?
এখানে শুধু ওয়ার্ক এডুকেশনের গেট
এটাই বলছি
The other is pending.
Other petition is pending. Physical education. কোর্টের কাছে জেনে নাও জেনে নাও কেন
অল আদার ম্যাটারস
এটা পুরো নোটিফিকেশনটা নেবে নাও
তাহলে ওগুলো অ্যাসাইনমেন্ট চাইতে হবে
অ্যাসাইনমেন্ট
so you have to ask for assignment lot এই
now
অ্যাডভার্টাইজমেন্ট আলাদা করে পিন আপ করে দাও
now you have used your affidavit.
No, we have not.
Who are you?
Out applications, we are
Wait.
State.
For the state affidavit of yours.
There were directions from time to time, which requires the Lordship's consideration today. I do not know why Mr. Bhattacharya has gone back on the hearing of the main writ petition. So long, Milord, we were all trying to find out, both the court as well as Milord, the bar, as to whether this physical education, work education, this aspect, whether or the creation of the 1,600 supernumerary posts were the subject matter of challenge in the pending special leave petition.
No,
That
first, Mr. Dotto, please. Since the challenge was the capacity of the state to create such post, the court posed a question. Since the issue of creation was been directed, how it was created by the coordinate bench, travel to Supreme Court. Incidentally, it will not be a question before the Honorable Supreme Court that whether you have any capacity to create it. No clear-cut answer could be given.
But let us look into the orders that were passed.
Now, that issue is over now.
No, that issue is very important for me. It is not over so far as I am concerned. My lord, we were trying to impress upon the court that kindly permit us, kindly vacate the interim order which my lord was pleased to pass on.
No, Mr. Dotto, possibly there is another rider. This court particularly posed a question to the whoever appeared on the behalf of the state. I do not want to name that. That whether are you in a position today to give appointment to this? What is your stand in the Honorable Supreme before the Honorable Supreme?
Lord, please
this was candidly submitted. We are not going to, so long the Supreme Court matter is not over.
Lord, please have a look to my lord's order of
Yes, there was a stay. Then
18th of November 2022. Now thereafter, my lord, please have a look to the order of 18th of April 2024. 18th of November 2022, my lord was pleased to injunct filling up of the posts. Yeah? Okay.
Yes.
Just give me a moment, my lord. Yes. 18th of April, my lord, 2024. To clarify, what is found there? 18th April 2024. To clarify as to whether the issue under consideration in the instant writ petition has any nexus with the issue involved in the pending SLP number, etc., leave was granted to the Commission and the State to file supplementary affidavits to their respective affidavits in opposition. Such supplementary affidavit was sought to be filed today, but they lack the clarification as such are not accepted. The State and Commission, if intend to file such supplementary affidavits, those must be affirmed within a week from the date by the Principal Secretary of the Education Department and the Chairman Commission, respectively, with necessary clarification immediately after affirmation, so and so. Then will I kindly take the next order of 1st of May. Mr. Bandopadhyay, learned Junior Standing Counsel, submits that in view of the judgment of the Honorable Division Bench in Boishakhi Bhattacharya and the challenge to the judgment before the Supreme Court, the circumstances have changed. As such, the state does not intend to file the affidavit in terms of the order of 18th April at this stage. However, the prayer, etc. Then please take me to 13th of May. The Honorable Supreme Court, by an order of 7th May, passed in so and so with connected matters, has taken note of the pendency of the instant writ petition before this court. This issue involved in the present matter, since is interlinked with the said pending matters before the Honorable Supreme Court, hearing of the instant writ petition is adjourned till so and so. So, all along the court was proceeding on the basis that something is pending before the Supreme Court. Kindly skip over 23rd December order. Kindly comes to 16th of January order. Mr. Bhattacharya, learned senior advocate for the petitioner, submits that the issue involved in the present writ petition is pending consideration before the Honorable Supreme Court in SLP, hearing of which has been fixed. He prays for hearing of this matter be adjourned till the matter is concluded. On the other hand, Mr. Sengupta, learned senior counsel for some of the interveners, and Dr. Patro, learned counsel for the Commission, jointly submit that the subject supernumerary posts have been created to accommodate the waitlisted candidates of the first SLST 2016 in the post of physical education and work education, which has no nexus and or connection with the pending matter before the Honorable Supreme Court. The subject matter of challenge in the present writ petition prima facie appears to be related with the, that is my Lord's observation, related with the pending special writ petition. Therefore, propriety demands that the hearing of the writ petition be deferred for the time. Then 1st of December, Millard, I don't trouble your lordship. And these are, Millard, the respective orders which I feel, Millard, is required to be brought to the notice of this court. Now, Millard, why I trouble your lordship, Millard, with all these? Because, Millard, we were praying before the court that the 18th November 2022 order be vacated so that in the supernumerary post, the appointments can be made in the meantime. To that, Millard, the writ petitioners wanted to say that the matter is pending before the Supreme Court. So, therefore, the High Court should not take upon it presently the burden of deciding the matter. Now, Millard, whatever has happened in the Supreme Court is before your lordship. Therefore, Millard, today my respectful submission would be that kindly vacate the interim order so that we
Come
can.
with an application.
Millard, in fact, Millard,
Come with an application.
these prayers were made, Millard.
I'm brought up in a civil court.
Yes.
I believe the court must act on in terms of, you may say that how far it is applicable. Come with an application. Your prayer is an application order under Order 39 Rule 4. Come with an application, I will consider. Not an oral prayer. Come with an application. Since the issue has already been dealt with, therefore there is no prima facie case. The interim order should be vacated. This is, come with an application.
Millard, I take the cue, Millard, from the Supreme Court's order.
Now today I
Please take.
I want to understand
Yes.
what should be the scope of
Yes.
the inquiry as to the in the present writ petition. How far the observations of the Honorable Supreme Court coming in the way in which portion of the prayer of the petitioner would be barred, or rather would be he will be not permitted to argue to what extent, because Supreme Court observations will come its way. What Mr. Bhattacharya has suggested, that CBI investigation cannot be directed or cannot be whatever have done. But the supernumerary post was created for a purpose which cannot be created, and that is his principal challenge. And second one is, today the supplementary affidavit he is showing to make a challenge to the appointment, the preparation of the list itself. And in aid of that, as a piece of evidence, he is bringing the charge sheet. Whether taking cognizance of that charge sheet or observation, whatever, is permissible in view of the observations of the Honorable Supreme Court. But he want to expose the selection process of this work education in its entirety. Whether it goes to the beyond the scope of the petition, or this investigation would come in conflict with the observation of the Honorable. This much I want to understand.
Please have a look to the last order of the Supreme Court, or the 8th April order of the Supreme Court.
No, in this piecemeal way. I want to know, first of all, let me collect the data. Now, your affidavits are on record.
But first, I would like to address your lordship as to whether the charge sheet can be considered to be an evidence or not.
See, you'll be getting an opportunity to file a short affidavit.
Millard, please consider one thing, Millard, at the instance of, Millard, my learned friends may have a very good case. Let us assume for argument's sake that they have a very good case, or unsuccessful candidates have a right to come up with such a challenge. Let us, for the time being, assume. Though, Millard, finally we will say that they don't have a right. Be that as it, Be that as it may, Millard, my respectful submission is, Millard, assuming that, Millard, they have a right to challenge the entire selection process, Millard, in view of the order of the Supreme Court and in view of the constitutional bar. Whether, Millard, the creation of the supernumerary posts can be a subject matter of judicial review.
That sense.
Now, Millard, my respectful submission would be, Millard, like, Millard, we have bar, Millard, under Article 329, 324 in Part 9A. This is again, Millard, one of the bar that whatever happens in the cabinet, but that is precisely.
No, you are taking me again to there. I'm telling you. If you can bring this, I understand what you want to bring in. Now, the Honorable Supreme Court has specifically observed the decision of the cabinet to create such post cannot be the subject matter of whether investigation or decision itself. The decision cannot be exposed to any investigation before the court also. Yes, cannot be.
Right.
But in such event also, if he can take me to that place where he can satisfy the court that the supernumerary post can be created in a given situation, which is not in existence when you created it. I want that much and that far he may be permitted to demonstrate.
Whether, Millard, please consider, Millard, whether he can fish out evidence subsequently, if at all charge sheet is an evidence, subsequently to justify an action which was not.
This is for challenge, to throw challenge to the entire selection.
Yes, yes.
Now, his initial repetition, as I could gather, was that state cannot create this post. In a given situation, state can, but this is not a situation where state can.
But we'll address your lordship whether, Millard, my learned friend's client can invite the court to go into that.
Very well, we will.
Yes.
Now, the Mr.
My agony is, Millard, if the Supreme Court, irrespective of the observation of the Supreme Court, Millard, if there is a constitutional bar,
that you are always free to demonstrate.
Therefore, Millard, kindly hear us on this, and Millard,
very well.
Consider vacating the interim order of 18th.
That you come with an application. I'm telling you.
Affidavit by the
Millard,
you are not a party over here. Please, I'm hearing his petition. You are the recommended candidate from you at listed recommended candidate.
Yes.
Let me hear Mr. Bhattacharya on the merit of this first.
No, kindly, Millard, hear Mr. Bhattacharya to his heart's content. But in the meantime, allow the.
File with an application. Come with an
application. But it's there, Millard, in my application, supplementary affidavit.
State's application.
Yes.
State. But this was affirmed
20 April.
On 13th of February 2024.
Can?
It's not a can, it's a supplementary affidavit.
No, supplementary you will not do. Come with an application. Yes, this is the writ petition, opposition.
Lord, may I add
opposition.
Lord, your lordship,
the issue I will invite.
Certainly, but
on the issue I will invite.
not only thing, Mr. Bhattacharya said that entire selection process is under challenge, both panel and listed candidates.
Sir, please hear him first, then you respond. I will invite you because your assistance court requires. Because I am on the fundamental question whether the state can create the supernumerary post. No, it cannot be said. Can, but in a given circumstances, whether that given circumstance exists or to accommodate which kind of whatever his question is. Let me hear this first. Opposition by state.
Without him,
no, this is my supplementary affidavit.
Two supplementary affidavit too?
No,
opposition. I want opposition.
13th February.
No, এগুলো হতে পারে নাকি? क्या रे crazy. I am the petitioner number 3. Affidavit in opposition to the petition.
47 in last sentence.
Two more things. On the last hearing, your lordships were pleased to observe, well, since by the interim order, our clients are affected. He may be added as parties.
Sir, I will be hearing you. Of course, I will be hearing you since you are before, irrespective of you are representing any party. If it is a question of law, I will be certainly inviting you. Please wait for your turn. Don't leave me. I require your assistance.
But our prayer is, your lordship, here's the point of law. Allow the appointments to be made.
No. Only one.
This is opposition to it. Take it.
Yes, I have it. Yes.
Oh, you have become so smart. Everything.
No, I was always unsmart. You know that.
It's all about nothing to add to it.
Millard, today, Millard, whatever has subsequent.
Doctor, please answer my question. Nothing to add in view of the subsequent development.
Millard, 28 November 2022 and 25th April 2025.
Please answer me straight. Anything to add in your opposition?
Millard, today, Millard, I am more concerned about vacating the interim order.
I have heard your prayer. Yes. I have rather suggested a way. Please adopt that.
Give me 1 day time. I'll come up with
Yes, adopt that. Not in this piecemeal way. Please come to this. Is it anything addition, any addition, support is.
Milord, if Mr. Bhattacharya's client has not filed any amendment application amending the writ petition, this is what my case is.
So-
if he amends the writ petition, I'm not supposed to answer the supplementary affidavits.
No, there is something has happened.
Yes.
I may take judicial notice of the Honorable Supreme Court, but the subsequent events, you don't think is required to be brought on record?
Milord, Mr. Bhattacharya has brought it on record.
No, only this one. Only
But
this
if the petitioner does not take the trouble, I don't have, Milord, any obligation. He has to amend his writ petition. Very well, it's his choice. I don't say that he has to.
Mr. Bhattacharya, the Honorable Supreme Court's judgment can be taken note of by this court. You know the Evidence Act. Now the what is called Bharatiya
Judicial notice.
Shakho,
Shakho that can be taken note of. I can take judicial notice of that, judgment of that. Now this, no other subsequent event except this supplementary you are finding. You don't think that required to be brought on record?
If we will not get materials, we shall definitely will not bring it notice of the court.
No, make it. I want to start it.
As of
Why?
now, no. As of now.
No. So this is the supplementary affidavit.
Advisement.
You have used reply to this. State reply দেখি
আমাদের opposition reply দিয়েছিস? আচ্ছা।
By the petitioners. They have also used pleading connection with our application. Kindly allow our applications also. So they have used their affidavit.
আগের অর্ডারে রেকর্ড করা আছে, লাস্টের আগের অর্ডার আমি বার করে দিচ্ছি।
ওকে, বার করে দিচ্ছি, বার করে দেব।
We have also used our reply. An application for addition of parties we kindly allow.
No. I strongly oppose.
Let it be dismissed. কিছু তো একটা হোক।
বিষয়টা বুঝলেই অবশ্য করতে হবে।
Against those persons who are against whom allegations have been made, they are not parties before your lordship. Against whom allegations are made.
The allegations against the authority, not against an individual.
Of course,
If
one says
time will come when the allegation will be aimed to you, you will be heard, you will be added.
he says so that money has been taken, money has been paid.
He has said and he has produced some document. I have not taken
That's
cognizance
not
of it.
allegation.
That is
No, but
Harshit Patel in
This is-
2014.
there is a
Reply.
part-head matter with respect to physical education before your lordship.
Huh?
বার করুন তা। WPA 23784 of 2022 is part-head.
Prosperity Board.
Bring that file also.
অনির্বাণ পান্ডা। অনির্বাণ
It is
পান্ডা।
today appearing in the list? No. পাঠান বললেন।
23.
I am told
পাঠান আছে বলছেন যে
ফাইল নাকি এখানে এসছে,
কোথায় আছে ফাইলটা?
সে লিস্টে দিতে হবে।
Pleadings complete on that also?
ওখানে কি affidavit হয়ে গেছে?
একটা মামলা একসঙ্গে হচ্ছে, একসঙ্গে এই মামলাটা শুনছে।
Oh, no, my lord. No pleadings were there. It was marked part-head because lordship was hearing this matter as a lead matter along with the other matter.
Mr. Dotto, so far physical education is concerned, if you think that you do not require to file any separate affidavit or this affidavit will cover?
But if your lordship directs me, I
am not going to direct
No, but
you.
unless he amends his writ petition,
I have that or not that.
only
This
the other one.
physical other one, physical
But
education.
I am not aware of the other one.
Who is your advocate on record in physical
Mr.
education?
Bandopadhyay is here, but others are
No,
also
Mr. Bandopadhyay was
You
there.
do not want to be involved in physically. Why?
there.
Get yourself involved in physical matters also.
No, he was there. Mr. Shishanno was there.
But he'll inquire.
So, ওটা ফাইলটা কোথায় আছে? This is the pleadings is ready.
Yes.
This supplementary affidavit you are filing, have you served it on everyone at that means state?
এই একমাত্র সাপ্লিমেন্টারি এফিডেভিট তো এটা তো আবার
Supplementary, হ্যাঁ,
কবে কবে
supplementary.
ডিভার্স
এই যে এইটা দেখে নাও, এই যে
ঠিক আছে তো?
না, এটা আজকে
এই
না।
এদিকে শোনো।
হ্যাঁ, এটাই।
state and SSC has
No, can be allowed.
এই তো আজকে।
Please take your seat.
But can be
Please take your seat now. Yes, SSC, have you used your affidavit in this? দাও এই SSC affidavit টা দাও। You have used reply against the SSC? এখানে লেখো তো। On behalf of the petitioner, a supplementary affidavit to the on behalf of the petitioners, a supplementary affidavit to the writ petition is filed. Is taken on record. আমাকে দেখো
Interesting constitutional on that. Right.
তার আগে লিখবে
সুপার নিউমারি হচ্ছে সুপার নিউমারি মানে আমি এক্সপ্লেন করব।
আচ্ছা, এবার ওই ক্যান 1 টু ক্যান 5, ঠিক আছে, এগুলোকে একটা আলাদা ফাইল করুন, আর এগুলোর অপোজিশন রিপ্লাই যদি কিছু আলাদা অ্যাপ্লিকেশন বলে আলাদা ফাইল করুন। এই রিপ্লাইটা দিন।